Hi guys, in this session we are going to discuss about the topic on sections under Digital Evidence Act and law enforcement proceedings by digital forensics. This topic was chosen because of the proceedings which was followed by the digital forensics as well as the law enforcement agencies, which are the sections and which are the procedures which are followed has to be known. Hence we choose this topic and it contains the manual which was produced by the CBDT and other procedures which has been followed. So let's get into the video. In this slide, we are going to discuss how to define an electronic evidence. Section 3 of Indian Evidence Act 1872 define the evidence. Evidence means include all documents including electronic record produced for inspection of the court. Such documents are called as documentary evidence. The evidence which was produced in the court for inspections are named to be an evidence. And Section 2 of T of the Information Technology Act of 2000, which defines what is an electronic record. Electronic record means data, record or data generated, image or sound stored, received or sent in electric form or microfilm or computer generated microfiche. So here it becomes clear what is an evidence and what is an electronic evidence. In this slide, we are going to discuss about the admissibility of contents of electronic record when it is oral and when it is relevant. Section 22 of A which describes when an oral admission as contents of electronic records are relevant. So when an oral admission has to the content of electronic records are not relevant unless the genuineness of the electronic record produced is in question. The proof of facts by oral evidence, all facts except the contents of documents or electronic records may be proved by oral evidence, in which it is an electronic form. The oral evidence has to be confirmed the genuineness of the electronic record is produced. Admissibility of electronic records. Section 65A special provision as evidence relating to electronic record. The contents of the electronic record may be provided with accordance with the provision of 65B. 65B is the main evidence act which was admissibility of electronic records. 65B of 1. Any information contained in the electronic record which is printed on paper, stored, recorded or copied in optical or magnetical media produced by computer, hereinafter referred to as computer output, shall be deemed to also document if a condition mentioned in these sections are satisfied in relation to the information and computer in a question shall be admissible in any proceedings without further proof of production of original image where the imaged contents has been produced to the code has to be attached with the 65B. This it comes under the admissibility of electronic record. Here comes the 65B of 4. For the purpose of admissibility evidence, a certification shall have the following matters are necessary. Identifying the relevant electronic records relating to the certificate and describing manner in which it was to be produced. The details producing it should have the 65B of 2, that is the computer from which the output was produced, was used regularly to store the process information during its regular course of activities and throughout the material part of the said period. The computer was operating properly. This was being mentioned in the 65B, which was produced by the forensic person on behalf of the assessee. That device was performing in a perfect manner and all those devices names has to be entered and the certification of matter are to be stated to the best of knowledge and belief of the person signing the certificate, that is the officer in charge operation or management of the related activities. In this, we are going to discuss about the Digital Evidence Investigation Manual, which was provided by Central Board of Direct Taxes. The CBDT has given a Digital Evidence Investigation Manual, which was having 204 pages, which was produced in the year of 2014. The manual was basically introduced to guide the officer in charge how to seize the digital data analyze and how to use it in the assessment order. This contains the various performer like chain of custody, digital evidence collection forms, checklist and other forms related to the searched proceedings. They can take the help of the forensic person. All this become very important due to the allegation and the alteration to the original data, which was the hash value report which was generated as not to be modified during the case proceedings. In the procedure continuation, one person from the technical side and one person from the assessee side, two independent witnesses has to be present for the search and seizure proceedings. The remarks the technical person can be seen from the Panjanama, which was noted in the point number 7, where it is mentioned the other person of the person were present in the search and took an active part. There must be a forensic person that in relationship of a forensic expert. At the time of seizure, a unique device number has to be allotted to the same should be duly reflected in the Panjanama chain of custody, digital evidence collection forms, remark that can be seen from the Panjanama Annexure. These are the proceedings which has to be followed, which must be given as a procedures. Here the procedures continuation. All the potential digital devices that needs to be seized are photographed along with the respective reference like a visible number of the name of the room surroundings etc. The Panja should have some knowledge about various digital devices. Further, it include writing from Panjas that they should have been explained the various digital devices that have been identified. Also, the various procedures used in forensic collection. Proper documentation has to be followed for the digital evidence that is visible to the naked eye. It should contain the details mentioned in the digital evidence forms like the mobile name, mobile model, mobile serial number, IMEI number, etc. And the most important last point here comes the hash value has to be hash value which was generated for particular device has to be mentioned in the digital evidence form which has to be recorded in the Panjanama, and the assessee can seek the copy of the clone of those copies of the forms. In this section, the procedure continues. The original storage media, which has been two cloned copies of the hard disk, will be provided. One is to be considered to be the master copy, which has to be sealed, and the other has to be the working copy, which are working copy provided for the officers for the further case investigation. And the printout of the report generated by the imaging tools, which contains the hard disk details of information attributes, details of hard disk drives imaged, date and time, the most important hash value of the hard disk or the particular device has been generated. So, which has to be attached to the Panjanama and the Panjanama's annexure. So, these are the procedures of this content.